Good evening, everybody. My name is Kehinde Adegbite, and this is Kenny School of Law. This evening, I will be discussing wills and estate planning with my learned friend, who is based in Bayelsa State, Yenogua. His name is Okunoye. Okunoye.
Jide.
Jide Okunoye. I'm sorry for that. Jide, you're welcome.
You're welcome. Yes.
Okay. So I know you have written on estate planning in the past. I think your book, I don't know if you have a copy of your book with you, so that you show it and people can see it.
I have a copy there.
Oh, okay. That's wills and estate planning. That's great.
Yes.
And you know that I've also written on wills, and I have a copy here. This is how to write your will with ease.
Yes.
So this is a book written in, that should be in 2013, thereabouts.
Beautiful.
It's no longer available in hard copy, but soft copy is available on Amazon, and people have been buying it. I don't know whether you still have your book available in the market.
Yeah, certainly. Oh, we still have some hard copies too.
Oh, great.
And, we have it on Amazon as well.
Oh, that's great. That's interesting. So to start this conversation, I don't know if you have some quick thoughts to share on the topic, wills and estate planning.
Of course, certainly. Wills, everyone knows about what a will is. And a will actually is to express a desire. A desire as to what will happen to one's estate when a person is deceased. Now, that is one sense of understanding what a will is. And then another sense is understanding it in the sense of the document in which that intention is expressed. So the desire itself, the intention is a will. The document on which it is expressed is also a will, because since we're talking about wills here, it's important that we define it so that our viewers will be able to understand exactly what we're talking about. And since we're also talking about estate planning is a wider term. Will is just part of the tools contained in estate planning. Estate planning is like a box in which you have many tools. And one of the tools in that box is a will. So I think I need to say this in order to set the ball rolling.
Yes, I agree with you. Estate planning is a wider concept because it embraces so many other ways by which you can plan your estates. You can think about people that are going to inherit whatever you have acquired in your lifetime after death. But let me try to simplify will, because most of our viewers are non-lawyers. So in a simple layman's language, will can simply be defined as a document in which a person who can be called testator or testatrix has written instructions on how his or her property should be distributed after death. So that's just a simple way to put it. Now, I don't know whether you can tell us some of the requirements for a will to be valid, because from experience, I've realized that some people just want to, they don't want another person to know that they are writing a will. They don't want even a lawyer to know that they are planning something like that. They will just want to write something down on a piece of paper and keep it, believing that after death, people will get to know about it. So what does the law say one has to do in order to have a will that will be respected by the law, or that will be qualified for execution or recognized by law?
I think, yes, a will, in the sense that you have expressed it, which is a document, has a lot of formalities. It's a very technical document, and a lot of formalities have to be complied with in order to make it valid. Of course, for a will to be valid, really, it doesn't be prepared by a barrister. But because a barrister has experience in doing those things and has been trained to do them, it's always preferred to brief a barrister to prepare one. But anybody can prepare his own will. And I think that's the essence of your book, how to write your. Now, whether the will is prepared by a barrister or by the testator or testatrix himself, when we say testator or testatrix, we're talking about the person making the will. Two very important formalities have to be complied with. Number one, the person making the will has to be in a very sound mental state. Now, this is very important to state because many people defer will making until they are at the point of death or when they are very old. They think will making is for those who are very old.
Or when they are sick.
Probably. Or how people who are very sick and at the point of death, you know. And if a person is too sick as not to be in a very sound mental condition, it may affect his power to make a will. So therefore, it is important that a will is made when one is still young and sound, both in body and in mind. So that's one. Then number two, which I want to stress here, because those are the most important conditions. The second one is that there must be at least two witnesses who are going to execute the document. And the two of them must be present at the same time and be present in the presence of the testator. So there must actually be three persons in a room at any time a will is to be executed or signed. So the testator, the executors, two of them must sign in the presence of each other and in the presence of the testator.
Okay, Jide, let me quickly correct something. You meant to say the two witnesses.
Yes.
Yes, the two witnesses, because when you said executors, executors, I know you will later talk about executors. So you are talking about signature of two witnesses now, who must be present together while the testator signs, who must witness the signature of the testator, and whose signatures too must be witnessed by the testator himself. So please, you can continue.
Yeah, so those are the main formalities I intend to stress for now.
Okay, let me quickly chip in this. That a will must be in writing. It's also compulsory. That it must be in writing, because some people believe that, they can record it. They can do video recording of what they want to be done. They even think that recording it is more authentic than putting it in writing. Unknown to them that our law, especially in this country, in Nigeria, recognizes putting a will in writing more than recording it, either your voice or the video. That writing it down is much more important. And when we are talking about writing, you type it, because that will make it more difficult for anybody to tamper with. So I think that is important. So the point we have made is, for a will to be recognized, three things are important. That person who is going to write a will must have the capacity, mental capacity to write it. That person must not be mentally sick. That person must know what he or she is doing as at that time. Then the will must be witnessed by two independent persons who we call witnesses. Then we talk about putting a will in writing. Those are three important things that have to. Then the issue of age, that just came to my mind now, because it's not just anybody who can write a will. You must be of age, minimum of 18 years, from 18 years, in some cases 21 years. But 18 years, you have to be up to 18 years before you can write a will. So if the good Lord smiles on you and by 13 years you start acquiring property, you buy cars, you have houses, and you want to write a will, you are not qualified to write a will yet. You have to attain 18 years of age, unless we talk about those in military service. There are some exceptions, but we will not bother ourselves about exceptions today. So let's just focus about minimum age of 18 years to write a will. Now, Jide, from your own experience, why do you think many Nigerians, the idea of writing a will is as if you want them to die? So many people die in Nigeria without writing a will. And that is why you have money, unclaimed money in banks. You have assets that people don't even, relations cannot trace after the death of the owners all around. So many people don't write their will. They die, and after death, you have crisis because people don't know how to share. And those you don't even want to have anything to do with your property, they eventually, when you don't leave a will behind, that is when somebody dies intestate, eventually these are the people who will take over your property. Family relations at times will even chase your wife, your children away, and they want to take over everything because you have not left any direction as to how your property should be shared after death. So why have people not embraced the idea of writing a will?
Certainly, I think one of them is religion, because a will is actually the way it is, the way we practice it here in Nigeria. You understand that the Wills Act is actually borrowed from the UK as part of our colonial history. So religion, if someone is not a Christian, and anything coming from that angle may be termed to be a Christian way of doing things. So those who are not of the Christian faith may not believe in the procedure for making wills under the Wills Act. Of course, this is not to say that there cannot be a valid will made, probably under Islamic law. You know, so, but I think one of the major drawbacks is religion. And another thing is superstition, like you have pointed out to, that probably when you make a will, then the person dies. Immediately the person makes a will, you know. But actually, people don't understand that the dying and making a will don't have anything in common. There was some few years ago, close to 10 years ago, I was with a colleague of ours. One cool evening, we were relaxing somewhere, and he was called upon to quickly come and make a will that the man was dying. He was at the point of death. That he should rush and come and make the will before he dies. Come now. And the man will soon die if you don't come. And then he had to leave me and quickly dash down there to go and make the will.
And that's a wrong time to write a will. When you're about to die, you may not even know what you are saying. Yeah. So you cause crisis when you write a will in that circumstance, because your family members will go to court and challenge it. They didn't know what he was doing.
Yes, but they just wanted something in writing on paper, you know, and my colleague he had to rush, and he was praying that the man will still be alive by the time he gets there, you know. And he got there, and he met the man, and then good enough, they were able to quickly scribble some instructions down. And but the funny thing is that they made the will, and for the man did not die as expected by those who called the barrister to quickly rush down. He did not die. In fact, he lived on for many, many more years. The last time I checked, I asked my colleague, how about our client? Has he died? He said, the man has refused to die.
So that goes to prove that, contrary to the superstition, writing a will doesn't. I'm trying to look for the right word now. Doesn't mean that you will die earlier than your time.
No, it appears in the case of this man, it actually prolonged his life.
You see.
Exactly. And I've seen cases too. In fact, I was in court the other day too, and a colleague of ours rushed to me and was asking me, he said someone briefed him and was talking to him about making a will. And the man kept postponing it and was giving him instructions and all that. And suddenly the man died. And what will he do? That is the situation, since the man has an intention to make a will, but could not actually put it together and died suddenly, you know. So, of course, it's very clear. I told him, there's no will, there's no will. And you cannot make a will. No, you cannot make a will for a dead man.
No, you can't. You can't.
Yes. So,
talking about, let me quickly say this. Talking about the relationship between writing a will and untimely death. This is one example I usually cite, and that's the example of Rotimi Williams. Rotimi Williams wrote his will, the first will, in 1954. That's when he wrote his will. And you know, Rotimi Williams was born in 1920, if I'm not mistaken. He was born in 1920, and he wrote his will in 1934. That was in 1954, rather. That was at the age of 34. Rotimi Williams didn't die until 2005. He was 85 years old. He was 85 years old when he eventually died. So writing a will does not mean that that will fast track somebody's death. No.
Yes, but I think the problem with Rotimi Williams' will is that the will that was made in the 1950s could not have captured the properties that were later acquired.
Yes, Jide.
At that time.
Jide, that's another issue. I don't want you to go into that yet. We may go into that, but I want you to conclude. You know, you were talking about why people don't write their wills. You have mentioned the issue of religion, superstition, and I don't know whether
of course, expenses too.
Okay.
Expenses.
Okay, cost.
It will cost some money to involve a barrister.
Okay.
To prepare a will, you know, and then sometimes ignorance. Ignorance. Some people feel that they don't have enough.
Yes.
Property that deserves a will. So there are many things that people are ignorant about when it comes to will making. But there's one thing I want to point out, which is also very important. So those are some of the drawbacks anyway.
Okay.
For now.
Okay, let me also say that procrastination is another drawback. And you know, you cited the example of a man who has intention to write his will, but he was procrastinating. I'll write it. And I've met a lot of people like that. In fact, some people will start writing, they will contact you, they will start the process, but they will never finish it. You have another appointment with them, they will not keep it. And eventually they will end up dying without leaving a will behind. So our people, and in fact, when you mentioned the issue of religion, you know, you started by saying that because the idea of writing a will came from our former colonial master, because we inherited their legal system and the Wills Act, everything came from them. Do you know that even if we say that, okay, British legal system has some Christian origin in terms of religion, and people who are not Christians they may have some reservations about it. Do you know that there are Christians that don't even buy the idea of writing a will? I remember when I wrote my book, when the book was newly written, and I contacted a pastor. I said I want to come and talk to members of his church about wills. And he said will has to do with death, that in their church, they teach people about life, living, not death. So because of that, he never invited me to come to his church to talk, because some people feel that when you are talking about will, you are saying they are going to die, and they will say, I shall not die, but live. So people, some Christians also don't, even though when you look through the Bible,
so that's also part of ignorance.
Yes, it's ignorance. Yes, I agree with you. I agree with you. Then I think there is also this issue. So many people think that writing a will is too expensive, though you have said it. But if you can elaborate more on it, that is expensive, writing a will. It's not meant for the rich to write a will, because if you want to write a will, you need a lawyer, and a lawyer will be charging so much money that you may not be able to afford it. What do you have anything to say? Have you had some experience in that regard, that you realize that the cost of writing a will scares people away?
Yes. I think the impression is just in the minds of people, because any barrister that is preparing a will charge based on the size of the estate. So if your estate is small, you should know that you pay small money. Mm-hmm. If your estate is big, so everybody, you may be expected to pay something slightly more. So it means everybody can afford it. Everybody can afford it. If one is preparing will for an estate worth 100,000 naira, so nobody will expect that the clients will pay 100,000 naira for a will for an estate of 100,000 naira. So if you're preparing a will for an estate of $1 billion, you don't expect that you pay 100,000 naira.
Mm-hmm.
So everybody pays according to the size of
of their estate. But that can also be scary for people who have large estates, thinking that, oh, I have large estates, and all a lawyer is going to do is to prepare a document for me, and is going to get a huge part of my money because of the size of my estate. Is there no benchmark? Is there no?
No. You know that under the Legal Practitioners Act, the scale of charges applies as well to will making. It's documentation, just like preparing a deed of conveyance and the rest of them. And so the charges are not really special or peculiar, and everything has to do with the complexity of the assignment or the complexity of the estate, the ability of the clients to pay, the size of the estate, and all those things. So that's the guide really as contained in the scale of charges.
So the cost for writing a will is not fixed. It depends on many factors.
No, it's not fixed.
So it depends on the client, the paying capacity of the client. It depends on the lawyer too, who is preparing the will. So if you consult Jide, a big lawyer practicing and based in Yenagoa, Bayelsa State, to a lawyer in Ibadan like myself, we are talking about two different lawyers because of their location. So, and again, the size of the estate as well, as you have said. Then, but all this is subject to negotiation, right? Between the lawyer and the client. So
exactly.
The cost is not as out of the world as some people think. Okay, good.
No, it's not.
Good. Now, I don't know whether, we have been talking about will in relation to sharing of property. Are there no other purposes that a will serve, that some purposes that it serves apart from distribution of property?
Yes, like you have said, from the title of this discussion, it is wills and estate planning. You see, so we should understand that the term estate does not just refer to money, land, cars. The estate also includes human beings. And that is why anybody that is a dependent or who survives the disease is part of his estate, his wife, his children, his parents, and all kinds of people connected to him. They are part of the estate. So will making and estate planning has to do with provision for all these people, not just by distributing money or properties. That's to do if there is, for example, infants. So the provision of a guardian to take care of them, their welfare, is part of the purpose of will making. Mm-hmm. In fact, the instructions for burial, the place of burial, the expenses of burial, and so many other things are part of the contents of a will. So directives for how the body will be disposed of? Is it by burial? Is it by cremation? Or is it to be donated to scientists? Or probably an organ is to be donated for the purpose of science, maybe a heart, or maybe a kidney should be donated to someone who needs it. If somebody is still strong and healthy when he dies, he can donate his organs to someone who will benefit from it, his heart, his kidneys, and whatever organs of the body. So all these are things that can be contained in a will, and so it serves a whole lot of
yes. I agree with you. In fact, some people will go to the extent of specifying time duration within which they should be buried. Some will tell you that within a week of my death, please bury me. Within 2 weeks, bury me. And some will be silent. But if it is dear to somebody, you can say that, oh, please, don't take much time to bury me. I remember when Gani Fawemi died, in his will, he wrote it, that people should be given opportunity to see his dead body, to see that lying in state must be carried out for him in Lagos and in Ondo State, Ondo town specifically. Because if he didn't put that in his will, being a Muslim, he would have been buried within a maximum of 72 hours, I think. But he was not buried immediately because he gave specific instruction as to that. Then some we also talk about the cost of their burial ceremony. They will tell you that I don't want expensive burial ceremony. Please, just do it. A moderate one is okay for me. I don't want money to be wasted on that. Some will go to that extent. And as you have said, place of burial. Because I remember when this popular lawyer died in 2014. That is Bamidele Aturu. I know you will recall that name. Bamidele Aturu was a human rights activist. He died at the age of 49, thereabouts. When he died without leaving a will behind, and he was based in Lagos. There was some problem between his wife and the parents, the aged parents left behind in Ondo State. The parents wanted the corpse to be brought down from Lagos to Ondo State and be buried in Ondo State. But the wife said no. And that caused some, to the point that newspapers reported it then. I don't think Bamidele Aturu would have wanted that kind of publicity after his death, but because he didn't write a will and he didn't specify that. So people really need to know that beyond distributing a property, there are a lot of things you can do with your will. And that's one thing that Gani Fawemi did with his will. He did a lot with his will. In fact, when you are talking about a succession plan, he did that in his will as well. He addressed what to be done with his law firm and some other companies that he had. If Gani Fawemi had not specified in his will, maybe we no longer have Nigeria Weekly Law Reports. We still have it to date because he specified how that company should be run for as long as humanity exists. That's a great one. Now, Jide, the other time you mentioned executors, people want to know what are the roles of executors, because if somebody writes a will, after death, you are no longer around. It's just a document that you have left behind. Is it your lawyer who will take steps to ensure that the contents or your wishes are complied with? Who are those people? So I believe those people are executors. I know you want to say more. So tell us about executors. Is there any age requirement for executors? Is there any legal qualification for somebody to serve as executors? Please. Jide, can you respond to that?
Certainly. I think I covered this area really in my book, and I also want to mention some of those things which I stated there.
Okay, good.
So he stated here that he collects and provides safekeeping for the estate's assets and notifies creditors and pays all valid debts. He collects any sums owed the estate, files claim for retirement plan benefits and other benefits, manages the estate's assets. He has the power to sell assets as directed by the will or required by state law to pay taxes, estate expenses or legacies, and to keep detailed records of all estate transactions and submit records to beneficiaries and to the probate courts. So he distributes assets to beneficiaries.
Good.
So you can see that the executor has a lot of work to do. And that is why It's a position that is actually quite demanding, and from what I read out here. So in choosing an executor, one must actually choose someone who is trustworthy,
Yes.
who is reliable, and who is sure to carry out the duties.
Okay, good. Let me quickly also add that it is also advisable that you choose executors who are younger than you. So
No,
who are
certainly.
younger than the testator. You don't choose executors who are of the same age. That if people are dying by age, you are likely to go around the same time. No, you choose younger people.
Yes,
and you also carry those people along, that you are writing a will and you are choosing them as your executors, because some people will not pre-inform their executors. So it is after death that executors will get to know that they've been appointed as executors, and they will be surprised because some of them may not be willing. They don't want family crisis. They don't want to be involved in that. But if you have carried them along, you would have obtained their consent, and you'll be sure that these are the people who will be there, who will stand for you after death. So, and again, we should also let people know that you need minimum of 2 executors and maximum of 4 executors. So, and because I remember, I think one of the crises that hit Abiola, MKO's Abiola's will, was that he never informed one of the executors he appointed that he appointed the person. And after that, the person on religious ground declined to perform in that office. So as you have said, basically, executors are the persons that will take steps to ensure that your wishes are carried out. And they start immediately, they get to know. Immediately the person, the writer of a will dies, and they get to know that there is a will. Of course, they would have known because you would have pre-informed them that you write a will and you have appointed them as your executors. So they will take steps to ensure that, the contents of that will are complied with. Good. Now, and
then I think when we're still talking about executors, because we talked about a lot of duties which the office requires. So one area we need to talk about is payment to them. Are they entitled to payment for their services?
Yes.
Because it is actually very demanding, really, to be an executor. And it can actually also cost a lot of money.
Yes, yes.
Yes, because I know that when you go through the law reports, you see a lot of executors being sued, by beneficiaries and by all kinds of parties, So, and at the time those actions are filed, they may not be able to access funds from the estates to pay for the costs of those litigations. So you now find yourself in a situation where, by virtue of that appointment, you may start spending money from your pocket to defend.
But the office of executors is usually humanitarian. Let me use that word.
Yes, certainly, exactly.
So
that's the point.
You don't usually charge, and they are not usually paid, but they can be paid if the testator has put that in his will, how they will be paid. And again, if you are also using institutions as your executors, because you can use banks as executors, because most of our banks, they also have the trust section in their setup. So if you are using organizations as executors, usually there will be provision for payments, and executors will not be paying from their own personal pockets. It will have to be from the estates.
Yes, or if you're using a barrister as an executor, for example.
Yes.
The barrister will be entitled to his fees as well.
Yes. And some people also use their own children, some of the beneficiaries, as executors. The law does not forbid that. You can use some of your beneficiaries as your executors. Just carry them along. The only situation where you cannot use beneficiaries as your witnesses, because if you do that, that means any beneficiary who is a witness to a will lose his or her gift under that way. So it is important to also stress that point. Then, we have watched a lot of I'm trying to remember what we call this in Nigeria, Nollywood movies. I'm not a fan of movies. I don't watch most of them, but most of the Nigerian films, You know, you will see them portraying once, if they are in some of their films, they will be showing people reading of wills at home. A lawyer, they will invite a lawyer after the death of a family member who left a will behind, and they will come to the house and they will be reading the will and things like that. Is that how it is done? Should the will be read at home or as the probate registry? What is the proper thing to be done? And in some cases too, you also see them. I think we have addressed that before, where they'll be showing and they'll be playing a video of somebody giving instructions as to how his property should be shared after death. And we have said it has to be in writing. But I want you to respond to the reading of will. We see it in most of our Nigerian films.
Certainly, I've seen such things too. And of course, a will is not to be read in the lawyer's office or in anybody's room and parlor. There's a will, it is read in court. In some courts, you have the probate division, like in Lagos State. And I've witnessed a lot of will readings in Lagos State, and they are read in open courts by the judge. There are other states where there's no probate division of the court as such. So the probate registrar does the reading. So whether it's in open court or in the probate registrar's office, these things are done formally in the court.
Good.
Yes.
Then after a will has been written and the maker of the will is dead, what's next?
Yes, because the maker or the testator will have a copy of his will. The barrister who prepares it will have a copy as well. And there is also a copy to be lodged in the probate registry in the court. And of course, of all these, the one lodged in the probate registry is the most reliable. That is the real valid will. So it is to inform it is for the executors now to begin their work, of informing the probate registrar that so will that was deposited here, the testator has passed on. So the issue of reading of the will and so many other procedures will now take place from there. So usually the will is actually sealed with a wax, and so the executors and the beneficiaries will be invited when the will will be read, and they must ensure that the wax is unbroken at the time it is being opened. So therefore, the first step is to inform the probate office about the death of the deceased, and then other steps will follow.
Good. I know you mentioned the issue of lodging a will. I've seen instances where somebody will write a will, but the will not be lodged while the person is alive, while the writer is alive. But shortly after the death of the writer, you hear the children who are aware that their late dad left a will behind and will be contacting lawyer that, what's next? Our father did not lodge the will. Can we go to the probate registry now and lodge it? I'm aware that in Oyo State, it is not possible because they want to see the testator physically before they will accept lodging the will from anybody. So I don't know the procedure in Bayelsa State, whether the will can be lodged after the death of the testator of the maker.
Well, I'm aware that in most states, even in many states, you can actually lodge a will after the death of the deceased, and probably in Oyo State as well.
I'm aware that they won't allow it in Oyo State.
No, because
I think there is a provision in the rules. Oh, okay. You have had an experience.
Maybe it's a new development anyway,
okay.
But I know that I lodged a will in the probate registry in Oyo State about 10 years ago. And
Okay.
so I know that some of these things are done.
And you lodge it after the
and
death of the maker, right?
No, not by, they don't really necessarily have to see the testator. That's the point I'm trying to make.
Okay.
Yes, as long as it's being deposited by a barrister. The rules might have changed in any case, But at the same time, there are states too that will permit the will to be lodged even after the death of the deceased. The only problem is this, when it comes to that, is that, the issue of authenticity of the will now will come up if it's just been taken there after the death of the deceased, and the deceased is not available to maybe verify it. Yes, authenticate it, But if everything is correct, if it's properly signed and everything on the face of it, all the procedure have been followed, there are probate registries really that will accept it. But even if they refuse to accept it, for example, in a state like Oyo State, where probably they may not accept it, one can still obtain an order from court that the probate registrar be compelled to accept it. So it's possible, So usually there are detailed provisions on these things in the various rules of court. And some of them are a bit flexible. So it doesn't really mean that if the will has not been deposited before the death of the testator, that there's no way of getting it. There are certain steps that may be taken.
Okay, good. Now, because I think this video should not be too long. So, but before we end it, let's quickly address this. Now, we said it's that many people don't like the idea of writing a will, and many people die without leaving a will behind. What other things can people do to distribute their property without writing a will?
Certainly, there are many other options. Okay. For example, when husband and wife, when a man buys a land or a piece of property and puts the name of his wife as joint owner, he has made a will. He has expressed a desire, even without writing it as a will. By adding her name into that document, what has evolved, what has come out of that is a position of joint tenancy. And if he dies before the wife inherits. And there's no need to make any other documents to confer title of that property on the woman. Yes. So she takes naturally, and it's assumed that she is a purchaser. So that is one estate planning method. So one can extend this to children. So one can buy properties jointly with children, with parents, with any loved one, even with a friend, and just put the person's name in the hope that when one dies, the other person takes the property. So that's a very easy way of doing it.
Okay. Another way is people can also distribute in their lifetime. So, we say will is testamentary. You can do gift intervivors in your lifetime. You distribute what you have, especially if you have advanced in age. You have advanced in age and you have so much, that you may not need much again to sustain yourself. You have many houses, you have many cars, and at that point in time, you may not need more than a car. You can distribute other cars, other houses, give them out, or you sell them and distribute the money as well. Then that can happen. Then, but if one does not do any of this and you die, then we'll be talking about using customary rules of distribution to come into place, and some other things like that. Now, Jide, I don't know whether you have more things to say, so that before we conclude this, I know you have said it, that the idea of writing a will is not only for the rich, it's for everybody who has property. So, because some people believe that unless you have so much, if you don't have so much like Mike Adenoga, Femi Otedola or Dangote, you have no business writing or thinking of writing a will. So I don't know whether you have more to share before we close.
Yes, on a parting note, what I would say is that we're talking about estate planning. So you should have a plan. Everyone should have a plan. Like they say that if you fail to plan, you plan to fail. So one has labored all his life to gather things. So there should be a plan for those things. So a failure to plan as to what happens to them is to spell disaster. So that's just the point.
Yes, thank you. I believe this conversation has also cleared a lot of misconceptions. People would think that writing a will is only meant for the rich, and again, that is so expensive to write a will, and again, that as if it's only you must get a lawyer to write your will for you. You can as well write your will by yourself, even though it's better written by a lawyer, because a lawyer is the one who is professionally trained to do it. If you write your will by yourself, it may have some gaps, and those gaps can create problems. But this just also came to my mind. Another reasons why people write, people think that it is important to write a will is to prevent crisis after death. But people write wills. At the same time, you still have crisis after death. People still go to court. Rotimi Williams left a will. I think you wanted to talk about that, please. I think you may have just a minute to say something on that. He left a will. Still, his children are in court. He died in 2005. And till now, till as we speak in 2021, I don't think they have settled their case in court. So we have so many cases that in spite of a will, family members still go to court to fight themselves over that same will. So what's the essence of writing a will if it cannot prevent litigation?
Well, will or no will, human nature is human nature. And greed is a major component of human nature. So whether there is a will or not, people will display greed and selfishness. So what propels all these cases is greed, is selfishness. Everybody is thinking only about himself. Whether it's a Ghanaian's estate also went to court. Mohammed Fawemi went to court to challenge certain things. So, and at the bottom of all these is usually greed. So, but the good thing about making a will is that at least the testator who owns the property has expressed his desire as to how those properties should be distributed. So that will rein in or control the greed, and it will give a court some sense of direction as to which path to tread when talking about the estate. But if with which to even measure the intentions of the testator, so it may be a free-for-all, and it may be more disastrous.
Thank you, Jide Okunoye. I think this is a good point to end this conversation. Jide Okunoye, as I said at the beginning of this interaction, is a legal practitioner based in Bayelsa State. He's a notable lawyer practicing in all courts, in all courts in Nigeria, up to the Supreme Court. Soon, I want to believe it will soon be announced as a senior advocate of Nigeria. Am I wrong?
Okay, I accept that. Yeah. And I wish.
Okay, thank you. Bye for now. Bye.
Thank you very much, sir. All right.